Okay, we can get started. So thank you everyone for joining us. I'm George Moxley. I'm the director of the Firearms Research Center here at the University of Wyoming. The FRC is devoted to just fostering dialogue on all things related to firearms, whether that's the law, the history, the administrative state, court decisions, and so on. And as part of that, we have a series of seminars, virtual seminars, where we discuss various topics. Um, the seminars range from legal topics to non-legal topics, and you can check them out at our website, firearmsresearchcenter.org, in the under the resources tab in the video library. And I encourage you to check out the rest of our website and our resources that we have to offer. Um, we're very happy today to have Steve Halbrook. Steve, he's been engaged in civil litigation and criminal defense since 1978. He's litigated cases in Virginia. He's a member of the Virginia Bar, the U.S. Supreme Court Bar, all of the U.S. Courts of Appeals, the bars of all the U.S. Courts of Appeals. He's testified before Congress, both houses of Congress, on numerous firearms bills and nominations and of executive and Supreme Court candidates. He's got a JD from Georgetown University Law Center, a PhD from Florida State University in philosophy. He's an assistant. He was an assistant professor of philosophy. He's taught at George Mason, Howard, Tuskegee University. He's a senior fellow at the Independence Institute. He writes for the Vala Conspiracy. He's a prolific author of both books and law review articles, and is one of the preeminent lawyers and historians all in one in the area of firearms law. Um, Today he'll be speaking to us on the title of his talk, which is eligible for CLE, as many of you know, is Testing the Limits of ATF's Authority, VanDerStok v. Garland and Ghost Guns. Before I turn it over, I'll just say, if you have questions, feel free to put them into the Q&A feature. Um, we'll definitely leave about 10 minutes at the end to take care of some questions. 5 or 10 minutes at the end to take care of some questions. But if there's some questions that come along in the meantime, in the nature of clarification, feel free to put it into the Q&A, and if I'm able, I'll interrupt Steve and ask him the question on your behalf. So with that, thank you very much. And Steve, I'll turn it over to you.
Great. Thank you, George. It's a real pleasure to be on this program. This case in the Supreme Court, Garland versus VanDerStok, raises some really basic fundamental issues in terms of the extent to which an agency can rewrite a criminal law that was passed by Congress. What's going on is that Congress defined firearm and defined it to include a frame or receiver of a firearm. And what the Bureau of Alcohol, Tobacco, Firearms, and Explosives has done is to extend those definitions far beyond what Congress enacted or what was the understood meaning of those terms when they were enacted in 1968 in the Gun Control Act of 1968. First, a few parameters. We live in an interesting context now. The last term of the Supreme Court, the court decided Loper Bright Enterprises, which did away with the Chevron deference doctrine. Before that, if you litigated against the government would always argue, well, you have to defer to the agency's opinion about something because they're the experts, or Congress delegated them the authority to define these terms, or whatever the case may be. And the courts were being remiss under that doctrine in serving the judicial function. They're supposed to decide all cases and controversies. And instead, they were passing the ball to the agency and letting them decide the meaning of the law. And so this deference doctrine is no more. Another interesting case from last term was Garland versus Cargill. And in that case, ATF once again had promulgated a regulation extending the definition of a machine gun, which Congress defined in the National Firearms Act, very explicitly. It includes several alternative definitions. And what ATF did was to expand that definition in a general way and also explicitly to include so-called bump stocks. And last term, the Supreme Court decided that case adversely to the government. Congress wrote the law a certain way, and the saying that's my opinion, and I'm sticking with it. That's what the court basically said. Congress writes the law. Congress defined the term. ATF did not have authority to extend that term to encompass other activity that was not inherent in the definitions set by Congress. Another thing from the last term and also in the last decade or 2 decades even, the court has been more focused on textualism. The days of legislative history are long gone. If you want to know what Congress intended, you read the law that they passed, not what some committee said or what one person said in a debate in an extension of remarks that were never even uttered in Congress, potentially. So we've got the court's methodology is to read the text carefully, and if Congress has defined something, that pretty much tells the tale. Agencies don't have an authority to extend it. One other precedent I'll mention, it's a case that I argued back in 1992, Thompson Center Arms versus United States. And the reason that case is important here is that it was a National Firearms Act issue. It had to do with the meaning of a short barrel rifle, and you could read the law one way or read it another way. And what the court came down to is if there's any ambiguity in a definition in a criminal statute, including the National Firearms Act, then you construe the law favorably toward the public and against the government. That's the rule of lenity. It's based on due process. Due process requires that you have notice of what the law is. And if it's not written in a clear way, particularly if it's a criminal law, you bend over backwards to construe it in favor of a person that might apply to. So with those parameters in mind, let's look at the specific issue here. The Gun Control Act of 1968 defined a firearm as a weapon that is designed to or may readily be converted to expel a projectile by action of an explosive, and included a starter gun in that definition because back in 68 there were basically imported starter pistols that you could just modify in a very easy way, and they would fire 22 caliber cartridges. So obviously all starter guns are not firearms. Most of them are not. The ones you use at your track meet or your swimming meet are not firearms, but that had to do with a very specific problem back then. So that's part A of the definition of firearm. It's the weapon that is designed to or may readily be converted to expel a projectile. And then B of the definition says the frame or receiver of any such weapon. Now, Congress did not define frame or receiver, but it was a common sense term. If you think about the frame of an automobile, it's going to include the part of the automobile on which everything else rests. The wheels are attached to it. The motor goes on it. The seats, the body, all of that goes on it. And you wouldn't say that the frame of an automobile was just some particular part of it or some piece of metal that's not even converted to be the frame of an automobile. One thing that ATF got right in 1968 was to define frame or receiver by a regulation. And I'm going to read that regulation and think carefully about each word. Frame or receiver is that part of a firearm which provides housing. Think about so far that part of a firearm. In other words, it's an actual part. It's not something that might be converted into a part. A firearm which provides housing. So that's present tense. The housing is provided now. It's not something like you have to machine and make it so that it provides housing. And then it goes on to say housing for the hammer, bolt, or breech block, and firing mechanism. So all the major parts of a firearm go into this frame or receiver. You would the last part of the definition, and which is usually threaded at its forward position to receive the barrel. So that tells us that the frame or receiver is the middle part of the firearm. You attach the barrel in the front, and you attach a stock, either a pistol grip or a shoulder stock on the rear. And so it's the big major part of a gun. So that definition was on the books up until 2 years ago. So that was 52 years of the ATF's definition of frame or receiver being on the books. And then all of a sudden, 2 years ago, among other new regulations, there have been three in this administration that really have gone overboard and going beyond what Congress enacted. There's the definition of firearm and frame or receiver. That's what we're talking about today. There's also a definition of whether a pistol brace is a short barrel rifle. There's another regulation about what it means to be engaged in the business of dealing in firearms. And those are all subject to litigation right now. All of those have been enjoined by various courts. And this is the case, of course, VanDerStok that made it to the Supreme Court. So two critical issues are set forth in the brief of the Solicitor General. The Fifth Circuit ruled against ATF, and so Merrick Garland, the Attorney General, appealed the case. And here's the two issues that are posed in the first page of their brief. Number one, the definition of a firearm, not just as what I read to you a few minutes ago, but also to include a weapon parts kit that is designed to or may be readily completed, assembled, restored, or otherwise converted to fire a projectile. So it's not just a weapon that will expel a projectile, for example, but it's also a parts kit. It doesn't have to be a weapon. And it's something that you may supposedly readily, which is an ambiguous term, make or fabricate into a firearm. And not only that, when they explain that regulation, the definition of that regulation, they say, well, there doesn't have to be much to this weapon parts kit if it's got jigs, tools, blueprints, or if you can go on the internet and figure out how to fabricate it into a firearm. And so there we have the idea that a firearm can include knowledge. Is there a YouTube that you can watch and see how to drill and mill and grind and file and all these other things you have to do to make a kit into a firearm? And then the second issue, the second definition, had to do with frame or receiver. And there ATF extended the definition of frame or receiver to include a partially complete, disassembled, or non-functional frame or receiver that may be readily converted into a frame or receiver. Now, this is where it gets interesting. It's something that you may readily convert into a frame or receiver. Remember, we heard readily convertible in the definition of firearm as a weapon that shoots, that will or is designed to or may readily be converted to shoot or to fire a projectile, expel a projectile. So now we have a term readily convertible that appears in Part A of the definition. It doesn't appear in the statute in Part B, frame or receiver, but now ATF wants to put it in there. The rule, I can't quote the Latin, but if you say one thing in the statute and you say something else in the same statute, there's a rule that when you say it in part of it, and you don't say it in the other part, then the other part doesn't include that wording. And that's what ATF has done here. They've taken readily convertible from Part A and put it into Part B. So those are the two issues in terms of definitions. Now think about the implications of this. The Gun Control Act, if you look at 18 U.S.C. Section 922, includes all kinds of criminal acts. It's unlawful to transfer a firearm to a person who doesn't reside in the same state as you, for example, or it's unlawful for a person who's been committed to a mental institution to possess a firearm. So if something's a firearm, then it's unlawful. Lots of things are unlawful. If it's not a firearm, then it's not unlawful. So every one of those provisions in Section 922 start out by saying it shall be unlawful to do X, Y, Z. Then if you get to Section 924, what it says is that here's the penalties. If you violate a provision in Section 922, then you get 5 years incarceration, and so on. But if it's not a firearm, then there's no penalty because you haven't committed a crime. Now, what the penalty clauses do not say is that if you violate a regulation, then it's a crime. But if you redefine firearm to include things that aren't in the definition in the Gun Control Act, what you've essentially done is allowed an agency to redefine a crime and to punish you for a violation of their regulation. And so that's why it's so consequential that agencies don't have this authority. If you look at, there are two contrasting provisions in 920, one of them in 923, one of them in 924. If you willfully violate the law or regulations, then you can have your license revoked. And then in 924, a firearm can be forfeited if you violate the Gun Control Act or a regulation. But you don't see or a regulation in the penalty clauses for which they can incarcerate you or fine you. Another thing here is, what is the extent of ATF's regulatory authority in the first place? Section 926A provides that the Attorney General shall have authority only to promulgate such regulations as are necessary. And the Act in other places specifies specific regulatory authority. For example, manufacturers are required to place serial numbers on firearms in accord with such regulations as the Attorney General specifies. So you got quite a contrast between things that are illegal and things that there's regulatory authority over, and that does not include criminal conduct or defining what criminal conduct is. So I want to take a dive into history. Let's talk a little bit about how the language, the definitions in the Gun Control Act evolved, how they started out, because I think legislative history is something that we don't rely on anymore, but statutory history is important. If you see how a statute evolves and you see language being changed purposely, then you can read the intent of Congress in part by looking at what the older language was and seeing how they changed it. So if you go back to 1938, the Federal Firearms Act was the first federal firearms law based on the Commerce Clause that regulated interstate and foreign commerce in firearms. And it mostly applied to manufacturers and importers and dealers, but it also enacted the first criminal acts that if persons had been convicted of felonies, they could not receive in interstate commerce firearms, for example. But the Federal Firearms Act, the FFA, that's not Future Farmers of America in this context. It defined firearm as a weapon that is designed to expel a projectile by action of an explosive or a part or parts thereof. And so every single firearm part was included in that definition. And you wonder what they were thinking when they did that, because the idea that Congress would regulate interstate and foreign commerce in mere parts was pretty all-encompassing. just a spring or a screw or a trigger or a grip. What interest did Congress have in regulating that far? But that's what it did. And so at that time, the FFA was under the auspices of the Secretary of the Treasury. So was the Gun Control Act when it was enacted in '68, and I think it was in about the turn of the century, it was taken out of Treasury and put into hands of the Attorney General, where it rests now. Two important things in the FFA that you can contrast with the Gun Control Act. Number one is that it was a violation. It was a crime, rather, to violate the act itself, the law, or a regulation promulgated thereunder. And the Secretary of the Treasury was delegated power to adopt regulations that he deemed appropriate. And so there you have the secretary, an agency or a department defining by regulation what could be a crime, because it was a violation of law to violate his regulation. So we start having the first references at that time to what later became the definition of a frame or receiver. There are some IRS rulings and other kinds of guidance where the word frame or receiver was used, and the context defines it as basically the middle part of the firearm that provides housing for the parts into which you attach the barrel and the stock or the handguard. So then we go to, at that time also, originally there was no serial number requirement for firearms. So nowadays, of course, if it's a firearm, not an antique, it's required to have a serial number, the name of the manufacturer or importer, their location, the model if there is a model. But that was not in the original FFA. There was no serial number requirement at all. And then in 1958, Treasury, for the first time, required serial numbers on firearms, excluding shotguns and excluding 22 rimfire firearms. So there's a lot of talk about ghost guns today and firearms that don't have serial numbers, but that was not even a requirement until 1958, and even then for only certain kinds of firearms. And it was the '68 law that first required serial numbers on all firearms. So, as I mentioned, you had that part or parts definition to a firearm, and that was deemed unworkable. I mean, by the early '60s, you start having amendments to the FFA, and some of those amendments were going to change the definition of firearm. Initially it only said a weapon that's designed to expel a projectile. As the years go by between about '63 and '68 when the law passed, you have additions to that, like maybe readily convertible, converted to expel a projectile. The clause about starter guns was put in there. And then they said, okay, any part or parts business, that's unworkable. We're taking that out. And we're going to put the main part of the firearm there, the frame or receiver. And so that's how the Gun Control Act definition of '68, which has not been changed since then, evolved, and how it changed the FFA. So another major change was these early Gun Control Act bills included violation of a regulation as a crime, not just violation of the law. And so there came about in 1968 a debate on the Senate floor where a couple of members explained why that or a regulation has got to come out. And they said Congress should be defining crimes, not agencies. And we shouldn't forfeit our power to basically say what the law is. And so that got scratched out, and that's how we ended up in Section 924 of the Gun Control Act of a violation of chapter so and so or of a section of the GCA, whatever the language is, and they crossed out or violation of a regulation. So that was no longer a crime. So that was a very important amendment, and that's what, again, we can't lose sight of that when we're thinking about the issue in the VanDerStok case, because what ATF has done is basically authorized itself to define a crime, all of the crimes that are associated with something being a firearm. And so that's really the heartland issue in this case. If you look at 926A of the Gun Control Act, you'll see that the Attorney General can promulgate regulations, only such regulations as are necessary. And in 68, it was more discretion there. It said regulations that he reasonably deems necessary. And so that was put in with that discretion. And what I'm referring to ATF in 1968. It was not ATF at that time. It was the Firearms and Tobacco Tax Division of the Internal Revenue Service. That's who ATF's predecessor was. But just to simplify, we'll say ATF. So they promulgated regulations in 1968. In fact, the law passed, I think, in November, and the public only got like 30 days notice in terms of when the regulation would become final. And that's pretty speedy. You know, they had no internet then. How are you going to even find out what's in the regulation? But one thing 926A does say is that the regulation, the authority, that was the secretary then, could basically have an oral hearing if he so chose, and he did. And so there was an oral hearing maybe a couple of weeks before the effective date of the law, of the regulation, I mean. And so you did have a turnout of people testify on the regulation. I have a transcript. Actually, if you want to see a transcript of the only oral hearing on a regulation in U.S. history, look at my website, stephenhalbrook.com. We actually scanned the entire oral hearing, which I got through the Freedom of Information Act several years ago. And it's the only publicly available source for that. But you'll see some criticism of it for different reasons. And by the way, the 4473 form when you buy a firearm back then was only one page, including all explanations. And even then people thought, wow, how are we ever going to figure this out? Because you never had to fill out a form like that before. But there were two comments on serial numbers and on frames of receivers. One was critical. The proposed reg said to put all the information on the frame of receiver. That includes not just the serial number, but also the name of the manufacturer importer, the model name if there is one, and so forth. And the witnesses of that hearing said, we can't get all that information on the frame of receiver. And so ATF relented, and in the final reg, they changed it to allow the serial number's got to go on the frame of receiver, but the other information could then go on the barrel. And that's been the case up until 2 years ago when this new regulation that was changed as well, which is a problem for polymer frames or receivers, getting all that information on the frame of receiver instead of the barrel. But the second thing in the hearing on the frame of receiver issue was that there was a witness for Sarco, a company that still exists today. The owner, he's still around. He testified that actually we like the fact that you finally defined frame of receiver, because we had no definition before. And so that was a positive comment. That 1968 definition that was on the books for 52 years was positively received by the industry. So their thing stood for many years. There were different things that we could talk about that I think are important in terms of the administrative history. There was a problem came up. The fact that M16 receivers, like AR-15 receivers as well, there's two parts of it, the upper and the lower. And so the question came up in the agency, well, which part should be serialized? And the decision was for serialization purposes, why don't we say that the framer receiver is the lower receiver? But then it admitted that we couldn't be making criminal cases against a person that didn't have both the upper and the lower framer receiver. That's very compelling agency document. It's like exculpatory evidence because in the decades that passed, plenty of people were being prosecuted or requiring to get manufacturing licenses just by making or possessing a lower receiver for an AR-15. Be that as it may, the framer receiver definition didn't change for all those years. Oh, another intervening statute was Firearms Owners Protection Act of 1986. Two things are important there. That's when Congress changed the regulatory authority from you may adopt regulations as you deem reasonably necessary to you can adopt regulations only that are necessary. So it set an objective standard, and thereby there could be more judicial review of it. But the other thing was that the Firearms Owners Protection Act actually didn't do that's important here. It did not change the definition or it didn't seek to provide a definition of framer receiver. Nobody was complaining about ATF's definition. And there's a rule that when an agency adopts a regulation and it's on the books a really long time, and Congress revisits that same part of the law and doesn't make any change, there's a presumption that it just might be valid. Whereas if there's an abrupt change, like in the case we're dealing with 52 years after the fact, you got a total revolution in the meaning of framer receiver. If there's an abrupt change like that, then there's certainly less, I'm not going to use the term deference. You don't pay as much attention to the agency's opinion on that definition. It's kind of like the dog that didn't bark, the lack of congressional dissatisfaction with the definition of framer receiver. And remember, Congress revisited other areas of the law that had to do with or replicated the definition of firearm. In 1990, the enactment of 922R, which had to do with assembly of imported parts for firearms that could not be imported under the sporting criteria, that was enacted. And then in 1994, of course, the so-called assault weapon ban, which obviously redid definitions of types of firearms. And of course, that law was sunsetted in 2004, never to be heard of again. So anyway, Congress has never shown any dissatisfaction with the definition from 1968, and then ATF goes and makes a radical change in what they had defined back in 68. So that brings us up to the oral argument, and actually the briefs, and then the oral argument in the case. The briefs were filed basically over the summer. I analyzed some of the leading briefs in the Volokh conspiracy, and I think that's in your recommended reading for this seminar. One of the briefs that I thought was outstanding was filed by Rick Vasquez. He had been one of the leading technicians at ATF in the firearms technology branch. And he explained how difficult it is to fabricate an actual firearm from these kits that are at issue, the so-called ghost gun kits. Manufacturers for years have been offering like Glock kits or AR-15 kits. They provide partially machined raw material and instructions for how to make an AR-15 lower receiver, for example, or how to build a Glock pistol frame. You've got to do a lot to complete these kits, and the chances are that it's not going to work and you're not going to get tolerances right because they require milling and drilling, filing and reshaping, basically raw material that's partially machined. And so Rick Vasquez filed an amicus brief in the case explaining how difficult it is and all the things that can go wrong. It was kind of humorous. There was a West Coast reporter who got one of the pistol kits to build it into a Glock, and he couldn't do it, and he had to rely on a firearms expert, two different firearm experts, to try to help him to get it correct. He described it, the whole process is very intimidating, and is something that that he couldn't do by himself. And then on the AR lower kit, that's even more difficult. If you read the Vasquez brief or the summary of it that I've set forth in the Bullet Conspiracy post, you'll see all the things that can go wrong. For those reasons, average members of the public, if you want a firearm, buy the firearm. You want something that works, and you've got issues of malfunctioning or inability to work or safety issues that if you want to try to do something from a kit. So those are really, don't do this at home. That's, I think, wise advice. But because the government was acting like, oh, anybody can assemble one of these in 10 minutes. And that was totally ridiculous. And in fact, ATF had been sued 4 or 5 years ago because it had classified these kits as not being firearms or not being frames or receivers. And now, of course, that's all turned upside down. Another really good brief was by some of the law enforcement interests, and it focused on the tracing of firearms. To what extent is tracing really that important? The arguments made about the so-called ghost guns is that if they're self-made, which is completely lawful under federal law, you can make your own gun. But you're not required to serialize them. Only if you're a manufacturer or an importer are you so required. And so much ado has been said about, oh, ghost guns are not serialized, and so criminals can make them and they can't be traced. And so my question is, how really important is all this tracing business? If you look at the propaganda, you'll see the argument that, oh, all guns that are traced are found at crime scenes. And when you find the gun, law enforcement finds the gun at the crime scene, then they can trace it to the manufacturer, importer, down to the distributor, to the dealer, and then you can find out who was the first retail purchaser. Well, how many criminals leave their guns at a crime scene? Like, most of them aren't that stupid. They want to keep their gun, or they want to dispose of it maybe, so that the fingerprints can't be detected. And as a matter of fact, there are some states that the law enforcement authorities are instructed to put in a trace request for every firearm that they encounter. So if you're a little old lady and your husband just died and he had a firearm in the attic, and you take it down to the police station and you say, I don't want this, it scares me. You give it to the police, they trace it. Or let's say there's an unrelated crime, like let's say you're accused of a financial crime and they do a search warrant in your house and they seize, let's say you're a big collector, you're a high-end rich guy, and they seize 300 firearms. They trace them. Were these firearms seized at a crime scene? No. So the value of tracing has been greatly overrated. So that's a point of one of the briefs, because you've got all this sky is falling argument about, oh, these ghost guns are everywhere and criminals are using them. And by the way, where do criminals get their guns by and large? It's the black market, it's theft, it's burglary, straw sales. They don't make their own guns. Think about the the machining skills of a gangbanger and the patience that such person might have. Like, oh yeah, let's spend all this time on these kits and let's make something that might not even work. How about just paying $50 to this guy down the street? And I'm going to rent the gun for 24 hours and give it back. I mean, that's the way the real world, the criminal world really works. So you just, there's a lot of scare tactics going on with this issue. And I tell you, not only that, but even if all these allegations are true, you know, even if the ghost guns are raining from the sky, this is a problem for Congress to fix. Congress makes the criminal law. They set the definitions for what is a crime. And so that's really the issue here. The attorney generals of, I think, about 26 states, led by West Virginia, filed an amicus brief telling the court, look at what's going on here. This is not the only overreach in ATF's regulatory domain. It's the ones I mentioned earlier, the engaged in the business redefinition, the definition about pistol braces. And so that one, together with this one, there's three major regulations that have been promulgated by ATF in this administration. And they all go far beyond the purview of ATF's regulatory authority. And all three of them are under injunctions right now, except that the Supreme Court in the VanDerStok case lifted the injunction that had been imposed by the lower court. So that brief tells the court, look at the context in terms of this is ATF is kind of going wild with overbroad definitions, and it's not just on this one issue. You look at the totality. Speaking of which, you know, there's the West Virginia versus EPA, the major questions doctrine. If it's something that's a really big deal, and gun control is a really big deal in Congress, you know, people fight tooth and nail over what ends up being the definitions and the crimes and all of that. The major question doctrine says that if it's a major question and it's not clear an agency has authority to regulate, then they shouldn't do that. There was an earlier case, I think 20 years ago now, involving tobacco, where I think FDA tried to regulate tobacco in a way that they had never been authorized to do. Tobacco is another one of those big issues that if Congress wants something done, they have a fight about it and they reach a compromise and they decide what the approach is. It's not something for an agency to make up out of thin air. So those are some of the jurisprudential doctrines that are relevant here. The oral argument, let me say a little bit about that. I'm going to start with the closing statement by Solicitor General Prelagar, or maybe it was in the argument, not the closing statement. The issue came up about, okay, if you say that these kits, a receiver kit is readily convertible to being the frame or receiver of a firearm, how is that to stop you from saying next that a semi-automatic receiver is really a machine gun receiver because you can readily convert it by drilling a couple of holes into being a machine gun? I think Justice Barrett asked that question. And the Solicitor General Prelagar responded something like, well, if you have a pair of pants, they are not shorts unless you make it into shorts. Okay, so if you want to use what ATF has done with these regulations, what if you have scissors? You have a pair of long pants and scissors. Do you have shorts? Sounds like it under this regulatory scheme. Justice Thomas, he gets to ask the first line of questioning, the way the court proceeds nowadays. And this started because of COVID, and they were doing oral arguments on the telephone. And so that way they could keep some kind of order. Before that, anybody could just interrupt anybody else. I really like it the way the court does it now. The Chief Justice goes down the list according to seniority. and the justices asked questions. Justice Thomas asked, well, these definitions appertain to crimes, don't they? 922 and 924 of the Gun Control Act, crimes are defined and punished. And so by implication, what you've done here is extended the reach of the criminal law. He mentioned the term 80% receivers because that kind of has been an industry term. It's not really a legal term, but you could sell 80% receivers. I don't know who came up with that percentage originally, but it's just a marketing term. But ATF approved many items as not being frames or receivers. They were just partially machined raw material. And in fact, when ATF promulgated this regulation, they said, nothing we ever said before is valid still. So any determinations that we've made about something not being a frame or receiver, well, forget it. You can't rely on what we told you. And that led to a big outcry, by the way. That was first announced at one of the industry conferences where, the manufacturers, they rely on something not being a frame or receiver and then having it transformed into a frame or receiver. So the sources of your raw material and when you have to put the serial number on it, when you have to record it as a firearm, that's very important to the industry. And in fact, the impact of this regulation has been much more heavily felt on the part of manufacturers and importers than private gun makers. I mean, the thing is sold in the media as being about ghost guns, but really the adverse impact has been on the industry more than private gun making. But anyway, Justice Thomas was interested in that. Justice Kavanaugh hammered away the fact that what you're doing is expanding what a crime is. And the Solicitor General was kind of saying, oh, just a little bit. But a little bit's a lot when it comes to 10 years incarceration, let's say. Justice Gorsuch, as in other cases, was very interested in due notice and the rule of lenity. Justice Alito was as well. In fact, the issue came up about prosecuting people. Like I think it might have been Alito who asked, so if somebody doesn't know about your regulation or they don't know that if you classified something as a firearm, that you would say it's a firearm and they don't know that, would you prosecute them? And we had the most naive answer from the Solicitor General that, well, we probably wouldn't prosecute them. I mean, who's going to risk, their life and their liberty on an assurance like that made in an oral argument when the people in the field make the decisions to prosecute? The agents who generate the evidence for cases and then the U.S. attorney's offices that prosecute them. What do you mean they probably wouldn't prosecute because they didn't know the law? They do that all the time. And they say, well, yeah, there's a legal fiction. You know what the law is. So those assurances, they're really pretty worthless.
Steve, just so you know, we have 10 minutes left. 3 questions and one comment.
Okay, let's get on with the questions then.
Okay. So the one comment, one of our audience members here pointed me to the Supreme Court case that you referenced about statutory construction. The case is Russello versus United States, 464 U.S. 16. Here's the quote. Where Congress includes particular language in one section of a statute but omits it in another, it is generally presumed that Congress acts intentionally and purposely in the disparate inclusion or exclusion. I think that's the one you mentioned there. And if that sounds right, I'll put that in the chat for everybody here while you're answering the next question here.
In fact, that Russello quote is very widely used and a very important principle. I mean, why would Congress say something one way and not the other way? That applies to this frame or receiver. concept, because may be readily converted in Part A, but not in Part B, which is the frame or receiver. There's nothing in there about a frame or receiver is something that may be readily converted into one.
Okay, first question, I guess there's a three-part question here. It feels like cheating a little bit, so you answer however many parts you want.
Okay,
Um,
if I can remember.
yeah, there you go. So I'll read them all. One, do you think there's a high likelihood that the DOJ will withdraw from the case? If yes, do you think that SCOTUS will accept the withdrawal? And three, if the DOJ does withdraw, will the Fifth Circuit ruling be the law of the land, or will the rules revert back to pre-Biden interpretation?
Um, there's a new DOJ coming to town. They're not there yet. The argument was on October the 10th. So let's assume the court doesn't decide the case before the new administration comes in. Um, the, the Attorney General could propose a new regulation that would basically repeal this regulation. It'd have to go through the Administrative Procedure Act. But I think that by proposing it and then notifying the court that it's proposed, the court would have the option either of just putting the decision off or of dismissing the case as moot. It would be kind of in a twilight zone of mootness, though, wouldn't it? Because there you have, if you don't know what the regulation is going to end up being, that sounds pretty moot, but it's still there. So we'd have to see what the court did. But there are times when things change and the circumstances warrant the fact that there's no longer a case or controversy before the court. So that's certainly an option. The court would have to decide whether to decide the case or not. You know, the city of New York did that a few years ago in the lawsuit by the New York State Rifle and Pistol Association. It was the regulation where you couldn't take a handgun out of your home. And the city was really trying to get out of that case because they figured we're going to just lose. There'll be another Second Amendment precedent. And so they ended up changing the law sufficiently to satisfy the court that it was rendered moot. Majority of the court, there was a strong dissent by Justice Alito. So we'll have to see what the court did in that circumstance.
I'll put the site for that.
Did I answer all three parts?
I think so.
Okay.
I think so. I'll put the site for New York State Rifle and Pistol Association 1 into the chat here as well. Okay, next question is, where do things stand on the forced reset trigger issue? Excuse me, it appears that ATF has attempted to redefine not only frame, but also machine gun. I guess
Right.
Ways in one.
I know that ATF has written threatening letters to manufacturers and sellers. There's probably some litigation going on. I don't remember the names of the cases, but that issue has been mentioned in the briefing in this case somewhat. So for those who aren't aware, a forced reset trigger is one that there's some mechanics to it that makes it where you can pull the trigger faster, but you're still having to pull the trigger. And the definition of a machine gun is a weapon that shoots automatically more than one shot without manual reloading by a single function of the trigger. So it's unclear, you know, under the Garland versus Cargill case. I'm trying to remember if reset triggers, forced reset triggers were mentioned there, but I don't know where this is going to end up, but I do know that the new administration is going to pull back ATF's authority to some extent, and I don't know what their position is going to be on forced reset triggers. And keep in mind, it was the Trump administration that promulgated the redefinition of machine gun. So we'll have to see.
Gotcha. And one more question here. I am up from Brazil and currently working on a PhD thesis at the University of the South Pacific on Federation and Public Security. At least it's USP. I think that's University of South Pacific. Maybe that's University of Sao Paulo. Apologies. in the Brazilian on federation and public security in the Brazilian Constitution. I'm also a member of a research group at IDP in Brasilia, focused on SCOTUS studies, where Stephen JPA has participated. Given this context, I would like to understand how ATF regulations preempt state legislation. How do you see the VanDerStok v. Garland decision influencing this dynamic, particularly with ghost guns and the broader regulatory framework?
Okay, just a couple of preliminary comments. I actually did a discussion with a group of lawyers and jurists in Brazil a few months ago. I don't know whether he was referring to that, but on our gun laws and how they're administered here. And I'm going to make a plug for two of my books that are published in Brazil in the Portuguese language. One of them is the Gun Control in the Third Reich, Disarming the Jews and Enemies of the State, and the other one is Gun Control in Nazi-occupied France. And those are available in anywhere where books are sold in Brazil. I'll plug it that way. But what we have here is that ATF has regulatory authority. It's pretty well defined by Congress. And to what extent can they reach out and extend things beyond what Congress anticipated? Or I mean, that's one of the big issues in VanDerStok. And by the way, I'm not going to make a prediction on how the outcome of that case. Everything didn't go favorably, but neither did it go favorably in the Cargill case, but that had a good result. So, I mean, in the U.S., we're taught in 8th grade civics, the legislature makes the laws, the executive branch enforces them, and the judiciary interprets the law. And that got off base in the Chevron deference era, when you had basically agencies making the law and interpreting the law, the legislative and judicial functions. Anyway, this opens up a whole new discussion, and I'm not sure if I've added much insight, but if there's a further refinement of that question, I'll be glad to take it.
So we have about a minute to go here. If anyone has another question, you're most welcome, and in fact encouraged to put it into the Q&A feature. We'll give folks a minute here. I don't have a little typing indicator showing up, so we'll give folks a minute or so, and then if we don't get anything, we'll call it a wrap.
So I'll just say one of the amicus briefs that I participated in writing is the one filed by the National Shooting Sports Association, and it goes into this statutory history, goes back into the Federal Firearms Act and how that evolved into the Gun Control Act. And so if you're interested in reading up on that subject, you'll see a more complete discussion there. Also, this Harvard Journal article that I think is in our bibliography for this seminar goes into that in some more detail.
And I put a link to Steve's recommended reading materials for this session into the chat here. All right, well, it's 1 o'clock. With that, I'll say please join me in thanking Steve for joining us today and speaking to us. I know it's a webinar, so you can only see me clapping, but nonetheless, Steve, thank you very much. We appreciate it. This video will be online in the next week or so at the Firearms Research Center's website, firearmsresearchcenter.org/video-library, or you can navigate to it. And the video version is accredited for CLE as well, if you have any colleagues who'd like to watch it later on. Thanks, everyone. Thanks, Steve. Have a great
Thank you, George. Thanks for having me. Take care.
Bye-bye.